Okay, so let's talk briefly about modifications. As you can imagine, people try to modify probably more often than they should, or at least some of them do. So let's say, for instance, I've seen this case happen. Dad takes mom back to court because she got a 25-cent an hour raise. So she should be paying more child support, or he should be paying less child support. People I have seen personally, I had a client once, I think I said this in a previous video, complain about a $10 toll. People can use their kids as pawns to get back at their exes, and child support is no different. So many states have passed rules saying when you can modify. So if we're going to change the amount, we are generally going to change the amount if the guideline calculations will change. But will the guidelines change for a 25 cents an hour raise? Yeah. By $2 a week. Are we really going to go back to court every time a child support guideline changes by $2 a week? At some point, the court realizes that minimal changes are not going to be worth the court's time. And so most states say there are only certain times or certain reasons for you to be able to modify child support. In Indiana, it's a pretty reasonable standard. It has to, we're not going to do it less than a year. So for those small changes in guidelines, we can look at them on a yearly basis. But every 6 months for a 25-cent raise, we're just not going to do that. Or if the change would be more than a 20% difference. So Dad wins the lottery, and he wins the lottery to the tune of $1 million a year for life. That is going to be, for most people, more than a 20% change. That is a big enough windfall. Or Dad becomes permanently disabled. Now Dad can't work anymore, and that is going to be the opposite of a windfall. So that's going to change the guidelines more than 20%. We can take a look at that obligation on modification, but we are not going to allow people to just run into court and modify for every 25-cent difference in guideline calculations. In addition, later on when we talk about jurisdiction, we're going to talk about child support enforcement. So we live here in the Louisville area right over a statutory border. Isn't that fun? And there are federal laws or laws that are model laws that states have enacted in order to prevent people from forum shopping, just like in custody, in support. There's a Uniform Support Enforcement Act as well as the Custody Jurisdiction Act. And we'll look at those more in detail later on when we do jurisdiction. But I want you to know that there are federal laws and state laws that have been adopted by most states that keep people from forum shopping. This is a situation where your mileage may vary. I know of a situation where someone who has children in both Indiana and Kentucky is seeking a modification. And that I'm not going to talk about the merits of it because they really don't matter. But the modification was statutorily correct in Indiana. It was either longer than a year or more than 20% or what have you. And took the other parent to court in Indiana, and Indiana said Kentucky has jurisdiction. Went to Kentucky, Kentucky said Indiana jurisdiction, and it did not get resolved. That is unlikely, but evidently possible. And it's unlikely for a couple of reasons. When we get to the jurisdiction section, I've already told you that there are these national laws that keep people from forum shopping. And typically, a custody or a support order or agreement, once established by one state, will not be modified to another state, will not go to another state unless there's a reason for it. So let's say mom moves from Kentucky to Indiana and has an Indiana child support order. That Indiana order will be in effect because we are right over a border. Now, if they move, there are all these jurisdictional laws that tell us when we're going to go to another state, but if in a situation like that, someone can't just move across state lines in order to get a different level of enforcement or get a different guideline calculation because these orders custody and support tend to be continuing. So once in Indiana, it's going to stay in Indiana unless there's a statutory reason to move it to Kentucky. And in this area where we're so close together, we're right over a border, that's going to be a harder row to hoe than if you were to move several states away. There's also a body of law that talks about relocation, and we haven't talked about that yet, but keep that in the back of your mind, that when people relocate, when we are allowed to do that and keep custody of children is also influenced by state law. But we will come back to that at a later date. So your book also talks about one thing that you should be aware of. Many people, Kanye said it really well in his popular song several years ago called Gold Digger. And on his 18th birthday, I found out it wasn't his, right? People assume child support stops on the child's 18th birthday. That is not the case. There are multiple state laws that can impact this, but we're going to use 18 as the age of majority and talk about when support occurs after 18. Children, dependent upon state law, can be supported over the age of 18 if the child is disabled and needs care. And that support may continue as long as that disability exists. And so we may have a child support order for a child over 18 if they are disabled. Also, there are statutes that require parents to pay support for children while they are in college. Now, do they have to be going to college, not just college age? Yes. But we can seek support for children who are over the age of majority if there are college costs to be paid. So understand that 18 may not solve that. Okay. Children supporting parents. So understand that the support obligation may, under some circumstances, go both ways. I'm going to turn to that section in your text real quick. There are some laws governing the support of parents by children. I'm not going to belabor that too much because it's not as relevant to most family law cases as the other way around. So take a look at that section in your textbook. And I think that's all for this because we've talked about modifying, we've talked about applying guidelines, we've talked about post-majority support and different support models. So unless there's something specific that I need to clarify in the rest of your text readings for this week, that concludes our lecture on support. The main topics are looking at what the guidelines say, understanding who pays support to whom, that it's based on income and custody, and that it's also based on, it goes from the parent with less custody to the parent with more, parent with less income, or more income to the parent with less, depending on that guideline calculation. And also having other children and other obligations to pay will impact child support. And also remember that we only modify, we can't go to court all the time to modify. Look at the statute in your individual jurisdiction to determine when and how child support can be modified, but we're always going to stick pretty close to that guideline. The last thing I want to leave you with is child support and custody are areas where family law court can feel like the Wild West. Everyone has a story about a judge who went rogue and just did something out of the ordinary. It happens. Like that example I was giving you a minute ago about the Kentucky court said no, it's Indiana, and Indiana said no, it's Kentucky. What do these people do? I don't know. This is what frustrates a lot of people in terms of family law. Yes, it's difficult to talk to people who are using their children as pawns. It's difficult to have people in difficult situations. But for me, what I find frustrating about family law is that so much of it is amorphous. And I really can see that from looking at the equitable distribution assignment we did in assignment 1. You all got the statutes correct. And many of you had very different outcomes because what is fair to you is not fair to someone else. That is what is more frustrating to me about some of family law than anything else, because the concepts of what's fair, what's in the best interest of the child, what is necessary to a child's financial support are very, very different from person to person. Now that you know what the law is, you can understand that sometimes because the law is not clear or allows for different opinions to support judicial orders, you can understand how people can have such vast differences of opinion about how the system functions, whether it functions fairly, and whether we can do anything differently. That concludes child support for now.